when the victim would shower, the defendant would enter the bathroom and lock the door. Notice the victim would not be in his bed the following morning and would be sleeping in bed with the defendant, where he admits that he is in fact the father of this defendant's 5-year-old child.
The male teen victim of alleged sex abuse now speaking out, saying that she never initiated anything. Not only that, the teen now says that he's in love with the mother of his baby. We'll have more on what that young man is revealing about defendant Laura Karen and the forensic evidence of how baby Evelyn died. But the defense team is pushing back, saying that the toddler could have died from SIDS. We're getting you all ready for the court day ahead. Plus, also this hour, we're looking ahead to Stephan Stern's big day. He's got his final hearing before going on trial on sex abuse charges. This is we're fighting for justice for Madeline Soto. Plus, the jury hearing from a problematic witness in the Rose Petal murder trial. The victim's fiancé appearing in a prison jumpsuit, but allowed to stay quiet on what put him behind bars. All that and much more is coming up right here on Opening Statements. Good Wednesday morning to you and welcome to Opening Statements. I'm your host, Julie Grant. Are you ready for some coffee and some court? It is that time. Go ahead and grab that cup of coffee right now. We got a great show planned for you. Let's start things off with my opening statement. What do Kenny Rogers and A$AP Rocky have in common? They know when to hold them. Rocky is holding them right now. This guy is so smart not to take the stand. It's a risk he doesn't need to take in a case with a lack of forensic evidence and a shaky victim. Because if Rocky chose to testify, we know from the Jinx murder trial that Deputy District Attorney John Lewin would have crossed him incessantly, probably kept him up there for the rest of the week. I mean, really. He crossed Durst for 9 days. He would have had a field day with Rocky, especially with the claim of him using a prop gun. Rocky was smart to use other witnesses to make that claim without exposing himself to a John Lewin cross. He got the narrative that he wants the jury to believe into case evidence for their consideration without taking the stand. My friends, trial advocacy can be like a poker game. And I think A$AP Rocky is playing his cards right. And I think he has a very good chance at winning. That's my opening statement this Wednesday. Let me know if you like it. Right now, it's time for your daily docket.
Has she ever talked to you about boys?
A little bit sometimes.
Has she ever, because I asked Jennifer the same thing, has she ever disclosed to you about being sexually active with boys?
No.
Do you know if she's ever been sexually active with anybody in the past?
Not that I'm aware of.
The man accused of murdering 13-year-old Madeline Soto will be in court today. Defendant Stephan Stearns has a pretrial hearing related to his sex crimes case. That's going to start at 9 a.m. Eastern time. And in South Carolina, we've got testimony resuming in our newest trial, the Rose Petal murder trial for defendant Zachary Hughes. That starts up at 9:30 a.m. Eastern. And in Texas, we've got defendant Brad Simpson with a motions hearing at 10 a.m. You remember his name, right? This guy's accused of murdering his wife, Suzanne Simpson, her body still missing this morning. Now to our top story. The state's case resumes in the baby Evelyn murder trial against defendant and the baby's mother, Evelyn Boswell. The jury heard from the medical examiner who details baby Evelyn's cause of death and the forensic evidence found at the crime scene. Court TV legal correspondent Kelly Craft reports.
Julie, the state will continue presenting witnesses this morning in the baby Evelyn murder trial. Tough testimony to digest during Tuesday's proceedings as the medical examiner testified about the autopsy results of baby Evelyn.
Dr. Schmidt, did you form an opinion as to the cause and manner of death of Evelyn Boswell?
Yes.
Okay. What is your opinion?
The cause of death, homicidal violence.
The jurors also heard about a fingerprint found on the trash can, as well as a print found on the tinfoil placed over the baby's face. Both prints belonged to Megan Boswell. And Julie, some tense moments during Tuesday's proceedings when the judge told the chief medical examiner that he was going to hold her in contempt of court if she did not give a yes or no answer to the defense counsel. This was in regard to whether she could conclusively say that baby Evelyn was alive when she was placed in the trash can. She finally said that she could not be certain that the baby was alive at the time she was placed in the trash can. That's the latest from here in Blountville, Tennessee. Julie, we'll send it back to you.
All right, thanks to Kelly Craft for that report. So what does that little piece of evidence do to the case? Let's bring in our guests and talk about it. Here with me, attorney Kesia Early and private investigator Manuel Gomez. Good morning to you both. Kesia, what did you think when you heard that in Kelly's report about how the medical examiner can't definitively say whether baby Evelyn was alive at the time she was put in that trash can?
I don't think it was so much of her response. I think it was how it got there by threat of holding her in contempt in front of the jury. One thing you don't want to do as an expert is lose credibility with the jury, because a jury already sees that you're knowledgeable in that particular field. But when she finally got to that response, that does place some reasonable doubt. But then it's overwhelming evidence against her because, of course, you have the fingerprints, you have the defense theory that they claim that the baby possibly died of SIDS, but she never reported it. It actually took dad/grandpa to report the child missing. Then you have the various lies that she told to the agents, just led them on this goose chase. And of course, the evidence being found in the shed on the property. So although it does place a little reasonable doubt, I do believe that her actions does not show that the baby died of SIDS, but she tried to cover up a murder.
Yeah, great analysis, Kesia. Thank you for that. Manuel, I want to play a clip for you here, please. This is something Kesia just touched on. As you know, Megan Boswell's defense team is trying to point to SIDS as the reason for baby Evelyn's death. So let's take a look at a clip regarding that.
How did you rule out sudden infant death syndrome?
Sudden infant death syndrome is a diagnosis of exclusion. If you're found in the manner that the decedent was, upside down in the trash can, it's not sudden infant death syndrome.
You can't say that, doctor. If the child died of sudden infant death syndrome and then was placed in the trash can, that is possible, isn't it?
You're right. It could be a sudden death and then placed in the trash can.
Manuel, what's your response to the defense theory that Evelyn died from SIDS?
Well, I think this was an outreach to try to come up with something, because the evidence is overwhelming that she committed a murder. As a matter of fact, after deep analysis into this case, it is my sincere opinion that the reason why she killed this child, it was because of her boyfriend, Hunter. Okay, and there was testimony in there regarding Hunter not wanting the child to live with them. And I think that was the reason why she killed the child, because he didn't want to have this family together living. He just wanted her and him. And, you know, you got to look at the fact of the dysfunctionality of this family. You know, this girl, unfortunately, is a sick murderer. And I hope that she gets nothing less than life, okay, and gets the psychological help that she needs in jail. But SIDS, no. That was just an outreach to try to come up with some type of defense. Like the lady said, she was put upside down, wrapped in a blanket, in a garbage can. No.
Manuel, thank you for that. You know, I always love hearing your theories and whatnot, and I'm curious, as a follow-up to your analysis, if you were working this case and somebody said, what do you think the motivation is? What would you say to that?
The motivation is that she wanted to live alone with her boyfriend and didn't want to be a mom anymore. And that's my rock solid opinion in this case. And then the fact that she hid the child in the place where she considered a safe zone. It was her playhouse, Julie. This was a place that she murdered the kid, but she still wanted the body to be somewhat safe, and also intentionally wanted it to be found.
Wow. Oh, that gives me chills. I love your analysis, Manuel. Thank you for that. You know, and I've just got to say it, this case makes me think of the Leilani Simon case for the reason you just articulated. I see you both nodding there. You must be thinking the same thing. I'm sure our wonderful Cordies at home are too. Tweet us if you're thinking that as well about this. KC, I want to play a clip for you now. This was an interview that the jury got to see. We know Evelyn Boswell talked a lot prior to being arrested. So let's take a look at this one that was played for the people deciding her fate.
Let's get into the last time you saw her. Tell me what that time was like and when that was.
Well, actually, I want to talk about that. I've told TBI where to find her in Mendota. My mom took her to a campground and a silver camper, and if they don't go tonight, I'm going to go find her myself. Because I've told them, and they're not really, like, taking it seriously, and if they don't go tonight, like, I will go myself and go get her.
Tell them why they're not.
Don't get into that. Stop.
No, you need to defend yourself.
That's all they need to know. Quit.
They already know, Megan.
So, kind of go back into...
Sorry.
No, it's okay.
Can you edit that?
I want to know who's with her. I just asked my producers as we were watching that. We don't know. Apparently, according to me, we've tried to find out. We don't know who was with her. Casey, I know you're cringing as a lawyer. I'm guessing it was not a lawyer, maybe a process of elimination, not a lawyer there. What do you think of this?
There's no way that could have been a lawyer, because all the statements, the misleading statements that she said in the beginning, she does not seem like an emotional parent that wants to find her missing daughter. Actually, she's an unlikable character. If she gets on the stand in her defense, which I hope she does not, she will be obliterated. Her story, her personality, she's not a likable character. And in addition to her reminding me of Leilani, she also reminds me of Casey Anthony, because this is kind of similar, where the grandparents had to initiate law enforcement finding the child. And then there's the multiple ideas or the responses that she gives about her missing baby. She's not credible, and she is definitely culpable in this murder. And my heart, again, goes out to this angel that died at her hands.
Is beautifully said, Casey. Isn't that the truth? It's baby Evelyn, who we all feel so bad for, and everyone who loved her. And yes to Casey Anthony. Yes, we definitely see those similarities as well. Great point. Let's talk a bit about Evelyn Boswell and her pants catching on fire time after time again. The state showing all of these text messages and all of the stories she told about beautiful little Evelyn to the jury. I wonder what this jury is thinking about her with all of the different stories that she told that weren't true. Manuel, what are you thinking as you're watching these lies come in? You see her on videotape, and then you know the facts and what the forensic evidence shows. What's your opinion of Evelyn Boswell?
Well, the videotape you just showed right now is completely damning, and in my professional opinion, seals her coffin, okay? Because when you look at that video, she's actually smiling. Her daughter's missing. She's smiling, she's nonchalant. She almost seems happy when she's talking. That's not a mother whose child is missing. And the fact that, well, I'm going to do this and I'm going to do that. No, any mother would have went immediately and hunted down her child. And again, the text messages, the numerous lies. This case, unfortunately, for our defense team, is a complete loss. This is a slam dunk. Those videos is a slam dunk for any prosecutor, and she will get life.
I'm with you, Manuel. Boom, drop the mic right there. We're going to leave it right there until court starts up. As soon as it does, we're going to go in live together. Manuel Gomez, Casey Early. I'm so glad you both are on the program today. Stand by, please. We're going to hit our first break. Go refill your coffee. Here's what we have coming up next for you on Opening Statements.
The victim indicated the sexual assaults occurred 2 times a week for 4 years. That would be 416 separate sexual assaults this defendant committed against a child.
The teenage victim in the New Jersey teacher sex assault case is speaking out. He's saying that he instigated the relationship. Plus, Stephan Stern's in court for his last hearing ahead of his trial on sex crimes. But we're asking, will this case actually go? We got a former child abuse prosecutor joining us live.
It was the biggest story in the world.
People saw the facts differently.
Somebody manufactured evidence in this case.
This was kind of a crazy spectacle.
This case is a circus.
He was an icon.
They are in for the fight of their lives.
Everybody thinks you're guilty.
Trial and Error. Why did O.J. win? Premieres Sunday night, 8 Eastern and Pacific, only on Court TV.
This defendant has demonstrated inability to exploit her position to gain access and manipulate minors for her own gain, for her own sexual gratification.
Now to what's trending in true crime. In an exclusive interview with Daily Mail, the teenager who had a baby with his New Jersey teacher insists that he started the relationship. Former teacher Laura Karen facing up to 10 years in prison on charges that she raped the male teen who moved in with her when he was just 11 years old. The teen told DailyMail.com this about his relationship with Karen, quote, "They need to drop all charges. I wasn't groomed or raped or manipulated by her. She never initiated anything." He goes on to say, quote, "I started everything. If it was up to me, she wouldn't have been in jail. It's been 6 or 7 years. I'm 19, about to be 20. I love her with all my heart. She was there for me and my family." Wow. What's your reaction to hearing that teenage father's comments? Let's bring in our power panel. Still with me, criminal defense and civil rights attorney Casey Early, private investigator Manuel Gomez, and want to welcome in the solicitor for the 16th Judicial Circuit in South Carolina, attorney Kevin Brackett. Kevin, let me begin with you, please. What's your reaction to hearing that teenager's comments?
Well, you never know what's going on in his head, but, just looking at the facts, cold, dispassionate, you have to ask yourself, is any 13-year-old capable of making the decision to father a child? No. So where has his head been, over the last, I think they said they started when he was 11 years old. He started having some sort of relationship with her when he was 11. It's absurd. She was 26, 28 when he fathered the child. I hate that his head is in a place where he can't understand the position of trust and power that she had over him, and how she abused that, how she was required by the law to look out for his best interest because he was incapable of doing that. It's just sad. It really is.
It really is, Kevin. You're absolutely right. It's heartbreaking. He can't see that he's a victim here. He sees her as a victim, apparently. Casey, what's your reaction to listening to what he said?
I was thinking the same thing. He doesn't understand that even though he, quote, initiated that, a minor cannot consent. So even if in this state, it's the age of 16, but then you have the other layer where she was a teacher. She had a duty of care. So there's no consent at any age. And then the point that he doesn't even understand that he's a victim shows that the jury, I'm pretty sure, is going to see that not only is he still delusional in this case, that we know that this, quote, grooming started at a tender age of 11. Even though there's no evidence of sexual misconduct, there was reports that he was in the bed with her and some allegations of witnessing some sexual misconduct between her and this child. This is an unfortunate incident, and this is why we have prosecutors where they can disregard the request of a victim and continue to prosecute based on the law. So yes, this case is definitely sad.
Casey, thank you for that. I want to show you both something else he said when he was asked by Daily Mail about contacting his child. So apparently there's a no contact order in place. We can infer that based on what he said. He's saying, quote, "I can't talk to them. I wish I could, but I can't. And it sucks." Again, an exclusive interview with DailyMail.com. Ooh, Manuel Gomez, last but not least on our panel on this topic, what do you think when you hear this?
Well, like my colleague said, I'm very saddened by this case. It's extremely disturbing. What's even more disturbing is I'd like to know the reason why he moved in with her at 11 years old, okay? And that right there in itself was a red flag. But besides that, this is a case that there is no way to win. Now, I know her attorney's putting up a defense, but this is a slam dunk again, another one for the prosecutor. This poor child did not know what was happening, and there is no doubt in my mind that she's going to lose. If I was her, and I hope they're listening, take the plea. Plea out, and don't put yourself through this trial. All right. And then if it's meant to be and you two get married down the road, then fine. But the bottom line is she's not going to win. She's going to get the maximum sentence. There's no doubt in my mind. She should just take the plea.
That's smart advice, Manuel, really smart advice, especially for the child, because as you all know, there's another victim here. The baby, right? The baby that they had is another victim in all this, in addition to the teenager, based on the evidence. We're going to continue following this one. This one is far from over, this case just beginning. Manuel, I like what you said there. Perfect way to end this portion of our trending segment. We'll see if this gets resolved with a plea. But turning now to other trending news, get this. As his criminal case is slowly inching toward trial, one alleged killer is receiving a very strong showing of support.
Luigi Mangione, the defendant, is charged with 1 count of murder in the first degree and 2 counts of murder in the second degree, including 1 count of murder in the second degree as an act of terrorism for the brazen, targeted, and premeditated shooting of Brian Thompson, who, as you know, was the CEO of United Healthcare.
Luigi Mangione charged in the killing of United Healthcare CEO Brian Thompson. And get this. He's accepted over $300,000 in donations from supporters to help fund his defense case. And he's wealthy, but that's beside the point. As of this morning, Mangione's Give, Send, Go fundraiser has surpassed $350,000 with a set goal of $500,000. This was organized by the December 4th Legal Committee. The fund has seen more than 12,000 donors globally. Okay, this is astounding. People giving money to this very wealthy individual. But at the end of the day, can Luigi's big money combat the bad facts of the case? Let's talk about that with our power panel. Manuel Gomez, I want to start with you first. You began your career patrolling the streets in New York City, and went on to have a really illustrious career in law enforcement, serving in our military. We talked a lot about this case with you before we even knew it was Luigi who allegedly did the shooting. Do you think all this money will mean he can get past the bad evidence against him?
No. I know for a fact that the video and his memoir notes is a deal breaker. His video of the murder and the memoir notes of him actually talking about planning out the murder and his disdain and his contempt for the system proves unequivocally that he's guilty. So it's going to be his final sentence. And Julie, I feel this is just another classic case of affluenza. The fact of his privileged upbringing is what affected his ability to know what he was doing and the consequences for his actions. Again, this is a case that's disturbing. We have a murderer, a person that's a coward, shot someone behind the back, and we are raising over $350,000 to support him. Wow, it's sad what this says about society today.
I'm with you, Manuel. Affluenza. I've never heard anybody say that. I like that. Casey or Early, let me go to you next, please. Your thoughts on the big money and the bad facts.
Well, I'll say this, that the most important part of trial is jury selection. So in this case, even with the overwhelming facts and evidence, I wonder if his fans, and these are some of the words that they're saying, they're considering him to be this rock star and he's easy on the eyes. If the prosecutor does not spend enough time to make sure they weed out those potential fans that want to be on the jury, then even with the overwhelming evidence and the overwhelming facts, this could be possibly a hung jury or even an acquittal. So my concern is that focus on the jury selection, but I agree with my colleague, there's overwhelming evidence because you have the surveillance, you have his notes, and you also track the history of where he went afterwards. So I'm sure that there'll be an acquittal, but there has to be great focus on the jury selection.
Definitely. Great point, Casey. I have a...
Well, not acquittal, a verdict, a guilty verdict.
I knew what you meant. You know, it's funny, I didn't even catch it as it came out. I know. But I knew what you meant. We're all speaking the same language here. Yeah. So I have a statement. This is from Karen Friedman Agnifilo, who represents Luigi Mangione. Here's what she said about the defense fund. Quote, Luigi is aware of the fund and very much appreciates the outpouring of support. My client plans on utilizing it to fight all three of the unprecedented cases against him. Wait a minute, unprecedented? Okay, so he's got the New York case, got the federal case, got the Pennsylvania case. I think there was grounds for all of that charging. How about you, Prosecutor Kevin Brackett? Would you take us home on this segment and your thoughts, please?
Yeah, cold-bloodedly shooting a man in the back as he walks by, that usually results in a murder warrant in my world, so I don't know about unprecedented. And look, people are free to do whatever they want with their money. You know, we live in the land of the free and the home of the brave. If you want to send money to this guy, that's fine. I hope, and I agree with the comments of both of my friends here today, this is going to be a jury nullification type argument where they're going to sort of say, feel sorry for him, the evil insurance company, they had it coming kind of thing. But I truly believe that when 12 jurors are sat in the box and they are given the law and the facts, they will choose not to live in a country where anybody who feels aggrieved about any particular issue can pull a gun out and solve it with a bullet. That is not how we operate in the United States. If you think somebody's treating you unfairly, we have courts. You can sue them there. You can take them to court. And plenty of insurance companies pay a lot of money for failing to pay on claims that are legitimate. But killing people is never the answer. People cannot take the law into their own hands. And I believe the jury will ultimately come to the same conclusion and find him guilty.
Kevin Brackett, beautiful argument. So you took me there. I felt like I was a juror listening to what their opening statement should be. These prosecutors, when they go after him, exactly what you just said. They need to bring you in on that to help out. We'll leave it there for now. But of course, we're following all the Luigi news. And Manuel Gomez, we got to say goodbye to you. Always a pleasure having you on the show. Thank you so much for everything. Kevin and Casey are coming with us and want you to do the same at home, please. Here's what's next on Opening Statements.
We have a very strong bond. But, I'm the person she goes to when her mom gets in a fight with her and she needs someone to comfort her. And I'm that person for her, This girl knows nothing but love here in this house.
The man accused of 13-year-old Madeline Soto's murder returns to court today. But on his sex abuse case, we'll talk about that. Plus, the Rose Petal murder trial underway in South Carolina with a, shall we say, complicated witness taking the stand. We'll talk about what the jury doesn't know about the victim's fiancé. Welcome back. This morning, we're shining a spotlight on accused killer Stephan Stearns as he's heading into his final hearing before his trial on some 60 sex abuse-related charges. Stearns is also charged with first-degree murder in the death of 13-year-old Madeline Soto, his girlfriend's daughter, his girlfriend Jennifer. She has not been charged. Now, investigators say they found sexually explicit photos on Stearns' cell phone, and some of them include Madeline. He was confronted with that information in an interview with police.
I'm pretty sure you know what some of those pictures are about. You're a very intelligent person. I don't want you to discredit yourself by saying you don't know about all the pictures that are on your phone. I want to let you know you're not free to leave. You're being detained, okay? Do you want to know what you're being detained for? capital sexual battery, and possession of child pornography.
So the sex abuse trial is scheduled to begin on February 24th. The murder trial is set to begin in September. That's right, the sex abuse case is going before the murder case. So what can we expect in today's hearing? It's going to start up at 9 a.m. Eastern. Our cameras will be there. Will we see a plea, or is this case moving forward? Let's bring in our special guest. She's a former child abuse prosecutor, a professor, and an author, attorney Wendy Murphy on the show. Wendy, good morning. Always wonderful to have you here. What do you think we might see this morning when Mr. Stearns goes back to court?
Well, I mean, the motions that are pending are pretty straightforward. A very common motion to suppress evidence. Of course, if he wins, the case disappears because you cannot prove any of these charges without the evidence that was obtained by police, according to his lawyers, illegally. If the evidence was obtained illegally, the case disappears. That is not going to happen. There's also, however, a motion to just continue things. And I suspect that will be allowed, partly because the government agrees to it. So to some extent, these are just run-of-the-mill motions. They are consequential, though. So yes, it'll be continued. But how much attention will the judge give to this motion to suppress? Because his argument is, I didn't give consent for him to search my phone. It is by the search that the police found all of these photographs of apparently, you know, him doing God knows what to children, but certainly raping Madeline. This is all in there in terms of the charges. But the police aren't stupid. If the police didn't have his consent, the whole case disappears. So police are very careful about making sure they do have consent when they search without a warrant. And I guarantee you the government's case will be, here's the video audio proof, rock solid proof that police did have his consent to search his phone when they searched it, and this is what they found. Case over. If this motion to suppress is denied, there will be a guilty plea in the future when the case is set for trial after the motion to continue is granted, because you can't win these cases. Once the evidence is in front of the jury, there is no defense. The photos speak for themselves.
They sure do. Great analysis, Wendy. Knowing that prosecutors are seeking the death penalty in the homicide case, curious to get your thoughts on the state's decision to move forward first with the sex crimes case and second with the homicide case.
Well, you'd think they'd go for the more serious charge first. That's often how things work. But there is a strategy to moving forward with these charges before the murder trial for a very basic reason. It's easier to win. And if you can get him locked up on anything, there's a much better chance for a plea bargain on the murder charge. There's a much better chance he won't get out on bail, which, you know, could happen. You never know. And there's also the possibility, based on how the evidence comes out with regard to the sex crimes charges, that those might then become admissible in the murder trial. You want to use those if you can. Primary reason, motive, explanation for how and why. People don't always understand this, but when children die and there are allegations of sexual abuse, it is often something that happened during the sexual abuse that caused the child to die. For example, children are often drugged with drugs like benzodiazepines. They are highly lethal for children, especially when used at high doses and sporadically. Why do pornographers and rapists and pimps and so forth use drugs? Because they create amnesia in the child, and a child who can't remember being abused can't testify. So it'll be interesting to see how this all works out.
Wendy, fascinating analysis from you. A couple other things that Stearns and his defense team are going to be raising today. I'm sure you've seen this, albeit, you know, more minor things compared to, you know, the motion to dismiss that's still out there. But apparently, if it moves forward, he wants to be unshackled during the trial He also wants to use a regular writing instrument, wants to make sure he can use normal instruments and doesn't have a restriction. Apparently in Florida, because of the nature of the charge, the judge could ban any sharp objects. And so those are a couple of things he's concerned with, his pen and no shackles. How do you think the court may rule with respect to those things, Wendy?
I'd give him both. I mean, he shouldn't be shackled. That's prejudicial. I'd let him do that. As for the writing utensil, just make sure he doesn't pull out crayons, because the false impression that he's mentally ill could work to his advantage. I've seen it before.
That's a good point.
It's usually a charade. I wouldn't allow that.
Right. You know, and I was thinking about that because when we were talking about it in our meeting this morning, I'm thinking, well, why wouldn't he be given a pen? I don't think I've ever seen a defendant with something else, but I wonder if they have iPads or something, if there really is a concern that someone might take a sharp object. Who knows? We'll leave it here for now. Wendy, thank you so much for all of your time and expertise this morning. We'll look forward to having you back very soon.
You bet.
Coming up next here on Opening Statements, here's what we've got. We've got a concert pianist on trial accused of murder. We're calling this one the Rose Petal murder trial. That's right, rose petals were scattered all around the victim's body when she was found. But we're talking about the victim's fiancé next and what could tip the scales.
The victim had been brutally stabbed multiple times.
A single mother found dead.
An unsettling crime scene.
With rose petals scattered around her.
The suspect, a classically trained concert pianist.
Now a jury must decide, did this musician
commit murder?
I think there's meaning and significance to everything a killer does.
The Rose Petal murder trial. Today, only on Court TV.
Now for what's tipping the scales in the Rose Petal murder trial in South Carolina. Concert pianist Zachary Hughes is accused of murdering Christina Parnell, stabbing her 31 times and surrounding her body with rose petals. The defense, who decided to reserve their opening statement, has maintained their client's innocence, and they're pointing to Parcel's fiancé, Bradley Post, as a potential suspect. Now, Bradley Post called 911 after discovering Christina's body. Post took the stand on Tuesday and described what he saw.
What did you do when you walked inside the house? It was dark, quiet, and so I walked back to, down the hallway to see if she was in the bathroom or the shower, and it was all dark. And I looked on the floor, and right at the entrance of the living room and off that hallway, there were petals from like a rose. And as I looked into the room, and I saw her on her back.
And when you saw her on her back, was there a lot of blood around the room?
Yes.
What did you do?
I walked over and yelled at her and then called 911.
But as they say, there's a lot more to the story, the fiancé's story in particular. What jurors don't know is that Mr. Post is serving time for child sex crimes. He is awaiting his trial. Now, will this tip the scales of justice? Let's bring in our legal eagles, attorneys Casey Early and Kevin Brackett with us. So should the jury know about Mr. Post's child porn charges? Let's talk about that first. Casey, your thoughts on that, please.
I was debating, Julie, because I had a case similar where one of the state witnesses were incarcerated for a case, and I argued to the court that the jury should know, and the court granted that. But in this case, I think that the court just did the analysis as to whether or not it was relevant and whether or not it was prejudicial. And I believe that the court made the right ruling. And I don't believe that this case will tip the scales, even with his testimony or the jury seeing that he's in custody, because there's still evidence against the defendant in this case. We have the DNA, and I just think that he inserted himself in an argument, in a custody dispute that really had nothing to do with him. And based on that, I do believe that the evidence suggests that he was the one that committed this murder based on this fight that Mr. John Mello, the ex-husband of Parcell, had over custody. Again, he inserted himself, and the evidence shows that he was there.
Casey, thank you. You know, on the stand, as you know, he was questioned about envelopes being sent to him containing naked pictures of Christina Parnell, the decedent in this case. Let's take a look at that clip together.
I received the envelope. I opened it because it was very suspicious, you know, with my return address. And I looked at it, and then I called my attorney.
Why did you call your attorney?
Because of the contents inside.
Can you explain, can you describe the contents?
Yes, there were naked pictures of Miss Parcell. And if I remember right, there was a mailing list of which would kind of indicate that they were going to be sent also to those locations.
Okay, again, correction, Christina Parcell, P-A-R-C-E-L-L, a victim's last name. Just wanted to correct that. Solicitor Kevin Brackett, as I was watching this clip, I kept thinking of a saying you probably hear every day in the courthouse. So you can't pick your witnesses, can you? When you're a prosecutor, you have to just put up who you need to put up. Would you talk to us, please, about what it's like when you have a guy like that and his testimony is important to the case at hand?
Well, obviously, every prosecutor wishes that that their witness list consisted of people from the church choir, but that's just not the way it works in real life. The jury obviously knows that Mr. Post has got some issues because he's sitting there in a detention center jumpsuit, so he's obviously awaiting trial for something. I think ultimately the judge made the right call in this by keeping that information out. This is a thinly veiled attempt by the defense to inject what's called third-party guilt into this case by raising the specter, the possibility that somebody else may have done it without any real clear evidence. And in South Carolina, the law is very, very clear. You can't just raise the specter or create the illusion that maybe this other person might have had something to do with it without being able to convince the judge that you have solid reasons for doing that. You have evidence of your own that links that person to the crime, not just the suggestion that they may have possibly done it. So out was the right call. Judge Fant did the right thing. And I'll hasten to add that though I know Walt Wilkins, the prosecutor that was in the video clip there, and I'm familiar with the case, I have no personal knowledge of it. So I'm just speaking from things I found in the media.
Oh, yeah, really appreciate the analysis, though. Kevin, thank you for that. I want to play a clip of the 911 call. The jury heard this. This already came into evidence. Let's take a listen together.
AJ Police Fire EMS.
I'm sorry? I think I might have a death.
Okay, let me connect you.
In my fiance's house, she wouldn't answer my call. There's a very weird smell. I can't get her to come around.
Okay, let me.
It's all over the floor.
Casey, do you find Mr. Post to be a believable witness?
I do. And oftentimes the prosecutors, just like you said earlier, they can't choose their witnesses, but they can educate the jury before the witness takes the stand. Again, this is why jury selection is very important. If the prosecution knows that they're going to have a witness that's going to be in jailhouse jumpsuit, then they need to bring that out to make sure that the jury will weigh his credibility the same way that they'll weigh the credibility of a civilian witness that comes in regular clothing. But again, the evidence does not suggest that he had any involvement. He called authorities. That's what someone does if they want to report it. But coupled with that, he's not going to harass himself by sending these nudes to himself or sending these nudes to his fiancé. It just doesn't make any sense. So when you put those together, you see that someone else is culpable of this harassment, someone else is culpable of this murder, and it's not him. Just like my colleague stated, you have to have a good faith belief foundation and evidence to suggest that he was involved, and there is none.
Perfect note to end on. Thank you for that, Casey Early, Kevin Brackett. Thank you both so much for your time and expertise. Always a pleasure to have you both on the show. We'll see you soon. And my friends, that's all for this episode of Opening Statements. But guess what? You can watch it again anytime. We put all the shows up there on your favorite website, courttv.com. Just click on the shows tab.